independent or free-floating power or mechanism for the court to intervene and change the party's bargain or moderate the party's bargain just because something is substantially unfair. So if it is something negotiated between, for example, commercial parties of roughly equal bargaining power, and they've been dealing at arm's length and all that, then the normal position is that fairness is not the court's business. The court doesn't really care if the bargain is unfair or not, even if it is very unfair. The exceptions that apply are quite narrow ones that are specific to certain circumstances. So I talked a little bit about the Unfair Contract Terms Act last week, and that applies to specific kinds of contracts, namely those that are between a consumer and a business, or between parties where one party is dealing on the other party's standard terms with little opportunity to negotiate them. But outside of that, and then in that case, there are certain tests like the reasonableness test that I discussed. But the answer generally, and it may not seem very attractive, is that a common law court will uphold unfair bargains unless there's some specific exception that they can rely upon. Okay, just maybe one last caveat to that, which is that what common law courts do, even in situations where there's no specific exception that applies, is that if a bargain seems very unfair, then they are likely to scrutinize it very carefully on the level of contractual interpretation. So if one party is arguing for an interpretation of a clause that would be very advantageous to them and very, very disadvantageous to the other side, then just as a matter of interpreting the contract and trying to figure out objectively what the parties intended by a provision, the court is going to be not so easy to persuade that the clause really has that very extreme meaning. So I think that is the one consistent safeguard common law courts do apply across all contracts, which is that the more unreasonable or extreme an interpretation of a clause a party is advancing, the more convincing the court will need to find that that really is what the parties intended by that clause. I hope that helps.
Okay, so let me elaborate it in bahasa a little bit. Jadi ada pertanyaan kemarin ya dari Gabriel ya, Gabriel. Jadi bagaimana jika jadi pertanyaan dari Gabriel Sihaan adalah kalau misalnya para pihak memasukkan limited clause ya, yang kemarin minggu lalu dijelaskan gitu ya, tapi kan ternyata dalam pelaksanaan ternyata kontrak ini menjadi tidak adil ya, atau berat sebelah kan, dan pihak yang merasa dirugikan kemudian digugat ke pengadilan tetapi kemudian bisa kalah karena dia kurang bukti dan lain sebagainya. Nah, menurut Prof. Lee sebenarnya memang pada umumnya di dunia common law ya, termasuk di hukum Singapura ya, hakim itu seperti sudah dijelasin minggu lalu, pengadilan itu akan sangat hati-hati sekali ya, untuk tidak menginterpretasikan konteksnya, mereka lebih kaku dalam memandang keberlakuan sebuah kontrak. Jadi sayangnya meskipun kontrak itu ketika sudah dijalankan ternyata menimbulkan ketidakadilan gitu, ada hal-hal yang dianggap belah dan lain-lain. Kecuali hal-hal yang memang sudah diatur dalam unfair contract act yang kemarin Prof. Lee sudah bilang ya, ada satu mereka buat undang-undang umum ya, yang membatasi keberlakuan sebuah kontrak. Jadi mungkin kalau seperti di Indonesia gitu ya, bahwa kontrak itu sah kan salah satunya kan harus mengikuti kausa yang halal gitu ya, termasuk tidak boleh melanggar peraturan perundang-undangan. Nah, jadi di Singapura memang ada satu kontrak khusus yang dibuat untuk membatasi kontrak. Jadi pembatas-pembatasnya sudah ditetapkan dalam undang-undang. Tapi di luar daripada itu, pengadilan itu akan sangat hati-hati sekali untuk bisa menginterpretasikan kontrak gitu. Ya, jadi ada kasus-kasus di mana memang para pihak, salah satu pihak akan minta ke pengadilan untuk melakukan interpretasi kepada kontrak. Tapi itu kalau terjadi demikian itu jarang, gitu ya. Biasanya jarang. Professor, if you allow me, maybe I personally have one question. Can you actually initiate like a court proceeding relating to contract matter? So,
I'm sorry, could you repeat the last thing? I didn't quite catch it.
so can you actually initiate like a proceeding, court proceeding with regard to contractual issues?
Sorry, is it possible to indicate a
Sorry,
what?
initiate a tort proceeding.
Oh, tort proceedings. Ah,
Yeah.
yes. So yes, it is possible. If I'm understanding your question correctly, do let me know if I misunderstood it. Even if you have a contract, it is possible to also have an action in tort, or although we don't have time to go into it today, you could also have equitable actions. But the approach that the Singapore courts take, which I believe, but I'm not 100% sure, would also align with the English approach, but at least the Singapore approach is that when there is a contract, because the parties have already agreed on a set of rules that apply between them, then even though it's possible for there to be tort claims and equitable claims as well, the court will first interpret the contract to determine whether the parties intended for it to be possible for them to bring other kinds of claims against each other. Because sometimes if there's a very specific and comprehensive agreement in place between the parties, the court might look at that and say, well, based on the terms agreed and based on the negotiating history between the parties, it seems that the parties intended for this contract to govern the entirety of their relationship, such that they wanted to exclude tortious claims. So sometimes the court will conclude that, but otherwise, normally the position is you can also have a tortious claim, and you could bring that concurrently with contract claims when you initiate proceedings.
So can a contract actually waive potential tortious claim in the future?
Yes, a contract could waive or exclude future tortious claims. And if it were a contract falling within the scope of the Unfair Contract Terms Act, which we discussed, then that would count as, well, actually, in any event, it will count as an exclusion clause or limitation clause. And then two consequences follow from that. One is, for certain kinds of tortious claims, the Unfair Contract Terms Act just prevents people from excluding that. For other types of exclusion of tort claims, then the reasonableness test might apply if the contract is of a kind that falls within the stipulated classes of contracts. If it does not, then to recap what I mentioned, the clause will be enforced, but subject to the court's interpretive powers to, as I mentioned in the previous class, look at a clause more carefully, the more sweeping the exclusion is. And then if it is, for instance, an attempt to exclude tort claims like fraud, let's say the tortious claim that a party is trying to say is excluded is fraud, like fraudulent misrepresentation or conspiracy or something like that, then because it would be very strange to exclude, or a bit unusual to exclude that kind of tort, then the court would want to see rather precise wording before it is willing to conclude that the parties intended to exclude liability for that kind of tort or to waive that kind of tort. But if it's something that is more ordinary, like negligence, then it's a bit easier to persuade the court that the clause was meant to address that kind of tortious liability.
Thank you, Prof. Jadi yang baru saya pertanyakan ke Prof. Liu adalah kemungkinan untuk mengajukan gugatan PMH gitu ya. Kalau di Indonesia ada konteks perbuatan melawan hukum dalam kasus kontrak, dan Prof. Liu menjelaskan ya itu juga bisa dimungkinkan di Singapura gitu ya. Tapi itu akan juga ada kemungkinan juga bahwa di dalam klausula kontrak itu dimasukkan pengecualian gitu ya, atau waiver, bukan pengecualian, waiver. Jadi istilahnya melepaskan hak keperdataan untuk mengajukan gugatan PMH gitu, itu dimungkinkan juga. Tetapi Prof. Liu itu menjelaskan itu akan dilihat kasus per kasus gitu ya. Misalnya kemungkinan justru yang diajukan gugatan keperdataan, yang diajukan itu adalah pengecualian terhadap gugatan keperdataan, misalnya terhadap kemungkinan terjadinya penipuan dan lain sebagainya. Itu pasti pengadilan akan melihat lebih detail lagi gitu ya. Kenapa misalnya ada kasus yang klausula yang demikian. Tetapi kalau misalnya atas dasar kelalaian, biasanya itu relatif akan lebih mudah. Prof. Liu, for now we can probably move forward with your next topic. Prof. Liu, do you already have access to Prof. Liu?
Yes. Let me begin sharing. Can I check that it's is it being displayed? Are my slides visible?
Yes. Okay.
Wonderful. Thank you. Okay, so thank you so much for all the questions. I think last week and this week, the questions have been very interesting and good, and I hope I've managed to address them at least partially, even if I don't always have the perfect answers. So this week, I intend to move on to cover clauses specifically related to dispute resolution. But before I do that, I think there are a couple of things from last week that I didn't manage to properly cover. So I'm going to spend a few minutes on that first. So liquidated damages clauses, I talked about briefly in an answer to a question last week. But just to clarify, in case I was a bit rushed and unclear, basically the question that was asked last week had to do with whether you can include penalty clauses. And I explained that in common law, and something that amounts to a penalty is unenforceable, but something that imposes the payment of a specific sum, but is not what the law considers to be a penalty, can be enforceable as just a liquidated damages clause. So the idea behind the liquidated damages clause, which I'm sure is a concept that you all are familiar with as well, being something that cuts across, I think, pretty much all jurisdictions. Liquidated damages clause is where you agree in advance on what the sum to be paid will be if there is a breach. And this is an example of a more sophisticated kind of liquidated damages clause that I pulled from a Court of Appeal case. Of course, you could have something which is as simple as if payment is late, the seller shall pay $10,000, something like that, right? But you could also have something more sophisticated where there's a formula provided, like in the clause I'm displaying on the screen. And that allows for a variety of different sums to be output depending on the circumstances of the breach. But it's still considered a liquidated damages clause because it is specifying through a formula that can be applied with certainty the amount of damages that shall be paid. So this is a clause that will usually be more likely to be enforceable, a clause like the one that I just showed. And that is because under the common law, the traditional test, and we apply this in Singapore, is whether the sum is a genuine pre-estimate of loss, meaning is it um, a genuine attempt to estimate how much loss a party would incur in the case of breach. And now it doesn't have to be accurate. In fact, it could be very inaccurate. The term there is not accurate pre-estimate of loss. The term is genuine pre-estimate of loss. So the question is, looking at the clause and the context in which it was negotiated and the nature of the transaction, does it seem that this is something that was intended as an estimate in advance, even if it ends up being wrong? Or was it something that was meant to sort of frighten or intimidate or deter the other party from breaching because the sum is very high? So there are a few factors that the court looks at. One factor that is especially important is whether the sum is greater than the largest conceivable loss, meaning in the worst case scenario, is it conceivable that the breach could cause a loss of that magnitude? And if it's not even conceivable, then that sum is likely to be a penalty. Another very important factor is whether the clause requires the same sum to be paid regardless of the type or degree of breach, or whether there is a differentiation between different situations of breach. And that's why I say that in this clause that I just showed and that I'm showing again, this is what I would consider to be quite a prudently drafted liquidated damages clause, because by providing a formula that will account for different degrees and seriousness of breach and the length of the delay and all that, it's much more likely that a common law court will look at it and say, well, yeah, this is a genuine attempt to pre-estimate the losses, and we can conclude that from the fact that there's a formula rather than one number that's supposed to address all kinds of breaches. So that's under the traditional common law test for penalty clauses, which applies in Singapore. If you ever have to deal with a transaction that uses English law, then it may be interesting and definitely important to note that the test is different there. The test in England is now whether the legitimate interest of the innocent party is basically the detriment imposed by the liquidated damages clause. This is a more, I would say, this is a more liquidated damages clause friendly test, because it allows for the possibility that even though the amount specified is not a genuine pre-estimate of loss, in other words, it could be higher than any conceivable loss, there's a possibility that an English court would still say it is a legitimate liquidated damages clause and not a penalty. In other words, they might say, yes, this clause is here to deter the other party from breaching, but there is a legitimate interest in the innocent party, in other words, the party that didn't breach, in deterring the breach. And I don't have time to go into great detail. It is quite an interesting concept. It does mean that an English court is more likely to enforce a liquidated damages clause than, for instance, a Singapore court. So that's something to bear in mind when dealing with English law contracts. So the effect, so just to clarify, the effect of a clause being found to be a penalty clause is that the clause will be unenforceable entirely. So the court will not moderate the clause downwards to make it reasonable. The court will just disregard the clause. That doesn't mean, of course, that the plaintiff doesn't get any damages, because a plaintiff is entitled to damages as a right under the common law in any contract claim, of course, dependent on them proving their loss and all that. So the difference is that in a liquidated damages clause, if the clause is upheld, if it is found to not to be a penalty, then the party will be entitled to the sum specified in that clause without any further inquiry into what the actual loss is. That's the benefit of a liquidated damages clause to the plaintiff. But if the court finds that it's a penalty clause and unenforceable, then the plaintiff would have to prove what the actual damages are in order to be compensated. And of course, there may be evidential difficulties with that, or their loss may actually not be very high at all. So you can see why parties would always prefer, well, not always, but will often prefer to rely on a liquidated damages clause rather than having to prove their actual losses. Okay, so maybe I'll pause here because the next slide I have is on force majeure. Yes, thank you.
Okay, I'll probably try to summarize a little bit ya. Jadi ini melanjutkan diskusi yang minggu lalu ya berkaitan dengan klausula ganti kerugian. Nah, jadi ada perbedaan mendasar antara ganti rugi dan penalti ya. Jadi kalau di common law itu klausula yang bersifat penalti itu tidak enforceable, nggak memiliki kekuatan hukum. Ya, penalti itu kan berarti sifatnya menghukum ya, menghukum yang mungkin tujuannya adalah untuk memaksa salah satu pihak untuk patuh terhadap kontrak. Ya, tapi kalau klausula liquidated damages itu maksudnya adalah ya klausula yang memang ganti kerugian terhadap kerugian yang memang secara material diderita, di mana jumlahnya, cara menghitungnya itu bisa dicantumkan di dalam kontrak. Meskipun nanti di pengadilan bisa kemudian hakim melihat lebih jauh gitu ya, apakah menggunakan beberapa pendekatan dan tes untuk melihat apakah cara penghitungannya ditetapkan dalam kontrak itu dapat diterima, masuk akal gitu ya. Tapi intinya kalau misalnya ternyata kriteria-kriteria itu tidak dipenuhi, maka hakim akan menganggap bahwa itu adalah klausula penalti. Jadi nggak bisa dilaksanakan, tidak memiliki kekuatan hukum. Oleh karena itu mereka harus mengajukan jumlah kerugian yang mereka tetapkan lagi gitu ya, bagaimana penghitungannya dan lain sebagainya. Itu ya salah satu perbedaan mendasar di dalam kontrak-kontrak common law adalah kita harus membedakan antara klausula penalti dan liquidated damages. Jadi kalau penalti itu nggak boleh ya, yang bersifat penalti itu nggak bisa dipaksakan keberlakuannya. Professor, I have one question. So in Indonesia we have what we call as immaterial damages. Do you have a similar concept under Singaporean law? Immaterial as in, something that relates to, psychological context of, let's say, an affected party, for example. Do you have something similar, and whether it is something that needs also to be, it can also be mentioned in a contract, for example?
Yes, we do. I think there are a number of kinds of losses or damages that I think could be described as immaterial, that are recognized under the common law. You mentioned psychological harm, and I think the common law generally distinguishes between two kinds of what we could broadly call psychological harm. One is psychological harm resulting in something diagnosable, like some sort of psychological condition that requires treatment, and the other would just be distress, hurt, upset, all that stuff. And both can be compensable in certain situations. Of course, just distress and upset and hurt are harder to claim for. The situations in which you would be entitled to them are less. And I think neither of those would be likely to occur very much in the context of contracts. We more usually see claims for psychological harm of various kinds in a tort claim instead. But one kind of harm that could be considered immaterial that you would more usually see dealt with in a contract and claimed for in a contract case would be something like reputational losses. for instance, loss of goodwill, harm to reputation, things like that. And yes, all this is claimable, but of course, there are always difficulties of proof when it comes to claiming such things, and so it always requires a lot more evidence and stuff to persuade a court that you have incurred X amount of immaterial losses. I hope that was sort of in the ballpark of what you were asking about.
Yes, thank you, Professor. Saya tadi barusan bertanya mengenai kerugian imaterial ya di dalam perikatan. Jadi menurut Prof. Liu, kalau di Singapura itu biasanya hal itu memang lebih banyak diajukan dalam gugatan-gugatan PMH ya atau tort claims biasanya, tetapi bisa juga di dalam kontrak itu ada hal-hal yang mungkin serupa, seperti misalnya kerugian berkaitan dengan reputasi gitu, misalnya karena pelanggaran kontrak dan lain sebagainya, ya kan, ternyata itu mempengaruhi reputasi salah satu pihak, itu bisa saja ya dimasukkan di dalam perjanjian. Okay, Professor, thank you. Please, all right.
Okay, thanks very much. So moving on to the last part of stuff that's actually left over from last week, force majeure clauses. So I don't have very much to say about this because the common law on force majeure and what we call frustration is really limited, and I would almost say simplistic. Basically, if you don't have a force majeure clause, then the only way you can change a bargain is, sorry, not change a bargain. The only way to deal with changed circumstances, drastically changed circumstances, is through the doctrine of frustration, which is two things. It's first very difficult to satisfy. It requires essentially that the contract, that one party's performance has to be either impossible or so difficult or so different that it would basically be to change the substance or nature of the contract to make them still perform. As you can imagine, it's very rare that a situation rises to that level. The second problem, at least in some people's views, mine included, with the doctrine of frustration is that it's entirely binary. If frustration is not met, then the contract is completely unaltered. If frustration is met, then the contract is discharged. So there's no middle ground where a court under the doctrine of frustration can modify the party's bargain to make it workable and fair. It's all or nothing. Because of that, if you ever are doing a transaction governed by English law or Singapore law or some other common law, it's extremely important, even more important than in civil law jurisdictions, to have a force majeure clause in there. Because the force majeure clause is where the parties can allow for contingencies that are not so extreme. So you can allow in a force majeure clause for instance, the suspension or modification of obligations. And you can make them contingent on events that are not quite as extreme as things that make the contract impossible or practically impossible to perform. So that's quite important. And when a force majeure clause is present, and here's just one example of force majeure clause from a Court of Appeal case, from a contract decided on in a Court of Appeal case, where there is such a clause, a common law court will give effect to it. Of course, there can be a lot of dispute over interpreting the clause and whether a particular event fits within the definition of the terms in the clause. That's unavoidable. But if you represent the party who may later have to rely on such a clause to excuse themselves from non-performance or to try to modify the contract to or suspend the obligations until they can be performed, then it's worth including, for sure. Okay, so that's all I want to say about force majeure. There's not that much, and I think I touched on it last week briefly. So maybe I'll just pause here to see if there are any questions on this before I move on to the dispute resolution portion. Thank you.
Oke, so silakan ya kalau yang mau bertanya ya. Dan sambil menunggu ya, jadi mungkin perlu saya jelasin sedikit ya, karena minggu lalu kita udah bahas bahwa di dalam dunia common law itu memang tidak mengadopsi asas atau prinsip good faith ya atau etikat baik ya. Memang secara sistem terdapat beberapa perbedaan mendasar gitu ya. Nah, mengenai klausula force majeure ini memang kalau di common law termasuk Singaporean law, klausula force majeure ini memang kalau memang dibutuhkan memang harus dimasukkan ke dalam kontrak, wajib gitu. Kenapa? Kalau kita membandingkan dengan Indonesia misalnya, yang namanya force majeure itu memang sudah merupakan bagian dari ketentuan umum ya atau default rules dalam KUH Perdata atau Civil Code. Jadi kalaupun misalnya para pihak itu tidak menyantumkan di dalam kontrak, ya kan dengan keberlakuan hukum Indonesia berlaku otomatis berlaku ketentuan umum dalam KUH Perdata. Ya ada ketentuan tentang overmark, ya. Nah, meskipun sifatnya sangat general, sangat umum gitu. Tetapi kalau di dalam hukum Singapura memang tidak terdapat doktrin force majeure ya secara dalam sistem hukum kontrak. Jadi mereka memiliki doktrin yang mirip tapi berbeda, namanya frustration of purpose. Dan menurut Prof. Liu itu dalam pembuktiannya itu jauh lebih sulit, jauh lebih kompleks ya dibandingkan dengan konsep force majeure. Nah, ini kita bisa melihat perbedaan-perbedaan dasar ya dari berbagai sistem gitu ya, dari kedua sistem. Nah, oleh karena itu ya memang di situ ada kebutuhan mendesak untuk harus memasukkan klausula force majeure di dalam kontrak. Kenapa? Karena kalau nggak ada, mereka nggak ada ketentuan umumnya yang akan otomatis berlaku seperti konteks hukum Indonesia. Prof. Liu, I have a question. So, I always thought that the force majeure doctrine and the doctrines of frustration of purpose actually is quite similar in context, like in the basic idea. But what do you think would be like the fundamental differences that you think that, because you just said that is quite difficult to argue for based on the doctrines of frustration of purpose from Liu?
Yes, I would say that there are two key differences in common law. One is that, for starters, there isn't really a force majeure doctrine under the common law. Instead, the common law just recognizes a class of clauses referred to as force majeure clauses. And so the one key difference is that the doctrine of frustration is always available for parties to argue because it's just part of the common law, whereas force majeure clauses have to be bargained for. And if there's no force majeure clauses, there's no scope for the operation of force majeure arguments at all. The second key difference is that force majeure clauses can be broader than the doctrine of frustration. I would say that I suppose because it's for parties to negotiate, it's theoretically possible for parties to have a very narrow force majeure clause, but in practice, the force majeure clauses are invariably broader than what the doctrine of frustration would be. The point of them is to include events that would not be considered or not necessarily be considered frustrating events under the common law, but to allow some kind of modification or suspension, or sometimes termination. You can also have a force majeure clause that allows for termination in situations where the doctrine of frustration might not give you any relief. So I think those are the two main differences. Force majeure has to be negotiated for, frustration is potentially available all the time, but very difficult to make out. And secondly, force majeure is a much broader concept. It can include any kind of event that parties think would make things difficult for one or the other party to perform the contract, and it can provide for different consequences, not just limited to termination. Yes.
So does Singaporean contract law in practice also include clauses like hardship clauses?
I think we would usually consider hardship clauses to be a kind of force majeure clause. I think the principles would be much the same. Yes, I'm not sure if legally there would be a difference under the common law between a hardship clause and a force majeure clause. It's more like just the kind of language you choose, but I think the effect would be quite similar.
Yeah, because both hardship and the force majeure doctrines are originated from the civil law perspective, but we don't actually adopt the hardship doctrine in our civil code somehow. But then the court actually, the way the Indonesian court in process, they by court decisions, they then differentiate between the concept of objective and subjective force majeure, and the context of subjective or relative force majeure actually reflects the concept of hardship, which is actually adopted in France, of course, in Germany, but not in Indonesia. So it does have a similarity in concept, I guess. But I'm just asking because the principles of UNIDROIT principles, for example, has adopted the doctrine of hardship, and which I think they differentiated with force majeure. That's why I'm asking how it works in practice in Singapore, whether you can also include like a specific hardship clause, or it can also be part of a general force majeure clause for you.
Yes, I mean, absolutely. There's a distinction drawn in other contexts. I think in the common law world, we would tend not to, simply because neither of these operate as doctrines in themselves. Both of these would just be concepts that parties could provide for by bargaining for it specifically. And so in terms of contract drafting, whether you label the clause force majeure or hardship and all that doesn't change the essential nature of the query the court is embarking upon, because to the court, although it's convenient to have this concept of force majeure clauses, and of course there's case law on force majeure clauses, on a basic level, it's just another clause where the parties have said, in this kind of situation, here's what will happen to our contract. And so common law courts don't need to care so much about these sometimes subtle differences, because it's all something the parties bargain for and have to put into words, rather than a doctrine that operates in the background by default. But that's really interesting. Thank you.
Can the court actually interpret a broad or general force majeure clause, or have you found in practice, evidences that suggest that it's better to have a more exclusive, limited force majeure clause, roughly?
I would say that I wouldn't go so far as to say that you need to be limited or narrow, but I think what I would say is that you need to be clear. Whether clarity means being specific about the narrow circumstances or being very clear that it's meant to be broad is up to the parties. But definitely there needs to be clarity. So for instance, in the RDC Concrete case, we saw this clause that defined force majeure as act of God or due to any cause beyond the supplier's control, such as market raw material shortage, blah, blah, blah. This seems like it's broad, but being a common law court, which tends, at least my experience, to be quite picky about language, and especially when the party is trying to rely on it to excuse themselves from performance. The court actually held that the clause that the facts of the case did not fall within the terms of the force majeure clause. So essentially, this was during there was a sand shortage in the 90s that affected the construction industry very badly, and so the price of sand and all materials incorporating sand rose very, very significantly. So this is one of many cases where whichever party had been contracted to purchase the sand and use it, right, the subcontractor, or to supply the sand. In this case, I think many of them said, well, sand is now so expensive, I should not have to perform the contract. And those who had force majeure clauses tried to argue that this was a force majeure event. The sand shortage was a force majeure event. And on its face, looking at this clause, you would think it would qualify, right? Because it says any clause beyond the supplier's control, such as market raw material shortage. It looks like that includes a sand shortage that makes sand and byproducts very expensive. But the court said, well, in this case, it's not beyond the supplier's control, and this is a phrase from the clause, beyond the supplier's control, because there was still sand that you could buy, but at a higher price. So I think on the fact this decision could be criticized, it is, to me, I mean, this is just my personal view, to me it is a bit strange to interpret the clause as meaning that so long as the supplier can still obtain raw materials, even at a much higher price, this is not an event beyond the supplier's control. That just doesn't seem to me to be what the parties could have intended, because anytime there are market raw material shortages, you will, if the fact that it says shortages and not complete stop or whatever, means that you can obtain the raw material. It's just going to be much more expensive. So if we interpret the clause this way, then I'm not sure how much the force majeure clause is going to be doing. So just on the facts of the case, I do wonder about the robustness of the factual reasoning, but I think the method here is illuminating still. It does show that when you're dealing with common law court, they can be picky about language. And so in this case, if the party wanted to be sure they were protected in the event of shortages that just cause the material to be much more expensive, then it would have been much safer to say something like, such as market raw material shortages causing drastic increases in the price or something like that, right? So that wouldn't really be making it narrow. That would actually be making it clear that it's meant to be broad. But basically, either way, whether you are the party who would be, because, you know, when you're representing the parties, you always have an idea of which party the clause benefits, right? So here, where you're talking about suspending things when there's market raw material shortage, then of course this is a clause that the supplier wanted to be included, not the buyer. The buyer has no incentive for that. So if you're representing the buyer, you probably want it to be narrow, and it would be wise to bargain for it to be narrow, clearly narrow. And if you're the seller, then it would similarly be wise to try to bargain for it to be clearly broad. You can think of a common law court as like a sort of how should I put it? The common law court is a bit like a naughty child sometimes, where you may wanted to do certain things, but if you tell the child in broad terms what you want, if the child doesn't feel like doing it, they will take their own interpretation. So you may have to be very clear with them. And for instance, if to continue the child analogy, rather than just saying put on some shoes, and then they might put on some slippers even though they're supposed to go to school, you have to say put on your clean school shoes or something like that. So that's the way I think of common law courts. They are meticulous in their reasoning, but they are often picky with language in the
Yeah.
context, and so you have to be very clear with them to be sure you safeguard your clients.
Oke, thank you Professor. Let me elaborate a little bit. Jadi tadi saya bertanya ya tentang kalau masukin klausul force majeure itu lebih bagus yang umum gitu ya, atau mau yang spesifik gitu ya. Nah, Prof. Liu tadi menjelaskan variasi-variasi putusan-putusan yang sudah pernah terjadi, dan menurut Prof. Liu, hakim itu intinya pengadilan itu pasti akan melihat ya kata per kata gitu ya. Jadi bisa jadi nanti bagaimana hakim menafsirkan pasal tersebut bisa jadi yang tidak sesuai dengan yang mungkin diintensikan oleh para pihak ketika membuat pasalnya. Ya, jadi misalnya tadi ada pasal yang menyatakan bahwa salah satu peristiwa force majeure itu adalah ketika misalnya ada kenaikan harga barang yang mengakibatkan tidak mampu dibeli gitu ya. Tapi ternyata menurut pengadilan dia masih mampu kok gitu. Karena kemampuan itu kan ternyata dimensi maknanya berbeda-beda gitu. Bisa kemampuan dalam arti ekonomi, bisa kemampuan dalam arti arti yang lain gitu. Jadi ketika hakim melihat bahwa masih ada kemampuan, berarti pasal tersebut nggak bisa digunakan. Jadi intinya adalah di dalam dunia common law itu kalau membuat kontrak itu harus sangat hati-hati dalam memilih kata-kata. Ya. Prof. Liu, one more question, because this is quite important when COVID-19 hit the globe. Yeah. In Indonesia, I remember that from April 2020 up to the next 6 months, one of the very sexy debate is among the contract law academics is on the issue whether COVID-19 falls under the framework of force majeure or not, which is an issue that the government was even very careful about, because it could also affect government contracts and all. So it was a very hot topic for a moment, and I don't think we even really came to like a solid conclusion whether it falls within the area of force majeure or not, because even the default rules of Indonesian contract law in the civil code is very, very broad. So how was it under this in Singapore, Professor?
Yes, thanks so much, Dr. Detania. It's a really interesting question, and the way different countries across the world dealt with COVID-19 effects on contracts is a really interesting topic. In Singapore, there was legislation that was pushed through quite quickly to deal with it, because there was a lot of uncertainty. I dare say even probably, of course I don't know Indonesian law well, but I would guess more uncertainty and doubt than in Indonesia, because, as I mentioned earlier, the idea of frustration is so limited in Singapore, and force majeure is something parties have to bargain for. So in cases where there are force majeure clauses, it wasn't so bad, because that would basically depend on what exactly the parties put in their force majeure clause. Like, did they include public health crises or things, or plagues or things like that as force majeure events? If so, then they're probably okay. If not, probably not. So if in cases where the contract had a force majeure clause covering diseases or disease-related stuff or public health-related stuff, then lawyers and parties could have a little bit of certainty. It wasn't so unsettling and uncertain. But then in a lot of contracts which did not have any force majeure clause, or which had force majeure clauses that did not include any language like that, the advice that most lawyers would have to give is, well, we can try to argue that it's a frustrating event, but it's very difficult to make out. So to give an example, before the legislative interventions, which I'll talk about briefly in a bit, um, before the Singapore Parliament intervened and passed laws to deal with it, if you were advising, for instance, the operator of a food and beverage establishment that suddenly has no customers because people have to quarantine at home, and the food and beverage operator wanted to, for instance, suspend the rental arrangement with the landlord, without a force majeure clause, it was very doubtful whether they would be able to suspend or terminate the contract because it was still possible for them to perform. There's nothing stopping them from still operating their F&B joint. It's just that they would make very little money because very few people were out or were allowed to be out. But under the common law, it is possible, but very uncertain whether even something as extreme as that would amount to a frustrating event. So there were a couple of cases that made it to the courts, including things like I think tourist tour operators, right? And in that situation, I think there was one case where the court did hold that it was a frustrating event, which makes sense because when it comes to tourism, it's even more extreme because people weren't being allowed into the country, right? And if they're not being allowed into the country, then how is it even possible to conduct tours? So I think there it succeeded, but it was all really uncertain. And for less extreme things like food and beverage operators or retail outlets and all that, everyone was very worried and uncertain. So sorry, I've gone on quite long, but basically, because of these limitations and because we have no general concept of force majeure, only a very narrow doctrine of frustration, Parliament quickly realized that this was going to be a problem and passed various laws, including I think they created COVID assessment tribunals, or I can't remember the exact name, where lawyers who volunteered to be placed on these panels could hear disputes involving contracts that were affected by COVID. And they were specially given powers to adjust the parties' agreements and to suspend or modify obligations in contracts in certain sectors. So that was that allowed, as far as I'm aware from people I've spoken to, that dealt with the practical problem quite well. But it was something that Parliament had to step in to provide. The common law could not have done it. And another thing that the Parliament did was they imposed a moratorium on insolvency proceedings because they reasoned that, well, a lot of companies are going to have cash flow problems now during COVID, and it's not desirable for them all to be wound up because maybe some of them can recover when the crisis is over. So there was a moratorium during which people could not apply to wind up companies that were not paying for reasons due to COVID. So that's another intervention that Parliament made. And I don't want to go into greater detail. Singapore government did quite a lot, but the two takeaways that I have from it are, one, the measures were effective, but two, all of this had to be statutory. The common law could not deal with any of this. And so similarly, you can imagine that in a normal situation where it's not a national crisis, a situation where the government doesn't step in, it will be on the parties to provide for such things in their force majeure clauses. And otherwise, similarly, there would not be any help from the common law because of how narrow the doctrine of frustration is. I hope that helps.
Thank you, Prof. Liu. I don't think I will elaborate this time because I've been asking you too many questions on that. But thank you so much for elaborating. And region government for sure needs to learn a lot from Singapore in dealing with that kind of emergency situation in the future. But please move forward with your lecture first.
Yes, thank you so much for the fascinating questions. So now I think I've got about, let's see, 40 minutes or so left. I'm going to move on to dispute resolution clauses. I think here I probably don't need to go into as much detail because I think alternative dispute resolution is something that all jurisdictions are concerned with now, mediation, arbitration, and there are courses in that, I'm sure, for those who are interested. So I'm only going to do quite a broad overview with a view toward, again, contextualizing it in the common law approach, rather than going really deep into what is arbitration, what are arbitration clauses and all that. But in a nutshell, when I talk about dispute resolution related clauses, I'm talking about those clauses that aim at providing parties with certainty about how they're going to resolve any disagreements that occur. And the first clause I'm going to talk about, although it's not really a dispute resolution clause, it's related. It's the choice of law clause. There was a question about this last week, which I dealt with in brief, but let me just say a little bit more about it. The choice of law clause is the clause that designates the governing law. You also can call them governing law clauses, the law of the contract. And common law courts give effect to parties' express choice of law. And it's quite important in a multi-jurisdictional contract to specify the choice of law, because otherwise any court hearing the dispute would have to decide based on its own conflict of law rules, otherwise known as private international law rules. And even between common law jurisdictions, there can be differences between the conflict of law rules. England does not approach conflict of laws the same way Singapore does, and Australia also is slightly different. And the differences, when you take into account also civil law jurisdictions like your own, becomes even more stark. So it's going to be really uncertain. If you have a contract that does not have an express choice of law clause, what is the law that a court would find is the governing law of the contract? It can be quite uncertain because different jurisdictions may look at different factors or apply different tests. So really important to have a choice of law clause. One simple example of the kind of language you might see is something like, this agreement shall be governed by and construed in accordance with the laws of Singapore or Indonesia or England or wherever. And this is, this clause does the basic job, but it's not ideal for a couple of reasons. And the reasons are related. Basically, there would be a bit of uncertainty as to the scope of the clause, because as you would know, if you've done, for instance, a course in arbitration, dispute resolution clauses, and especially arbitration clauses, are seen as operating sort of on a slightly different track from the substantive clauses in the contract. So you might have the clauses that tell the parties what concrete obligations they owe to each other, deliver X number of widgets by Y date at Z price, right? That sort of stuff. But then the dispute resolution clauses are considered to be separable or severable from the contract. That can be important sometimes because, for instance, there might be an argument that the underlying contract is invalid, but the dispute resolution clause might still be valid. And so for this and other reasons, there can be doubt as to whether the same governing law was intended to apply to the substantive contract and to the dispute resolution mechanism. Related to this, even if there's no uncertainty, so for instance, even if we assume that a court in a particular jurisdiction would look at this simple clause and say, oh, well, the parties must have intended the governing law to govern the whole contract, including the dispute resolution clause. Well, you might not want that. It may be better for the parties to or the parties might be of the view that it's better to apply different laws to the substance of the contract and to the dispute resolution mechanism for commercial reasons of their own. And so it's not always ideal to have just a simple clause like that. So here's another example of a more sophisticated choice of law clause. This is taken from the Singapore International Commercial Court's model clauses. This is a clause, I won't read it out, that is similar to the previous one, but makes it clear that the parties intended the whole contract, including the dispute resolution clauses, to be governed by Singapore law. A more interesting example, which I've got up on the screen now, is this clause, which provides for different law to apply to certain subclauses, and those subclauses would be the dispute resolution clauses, and to the rest of the contract. So this is one way you might draft a clause when you want to make it clear that the parties intend for their substantive agreement to be governed by one law, but they want the dispute resolution to be governed by a different law. And of course, there are different model clauses that are promulgated by different bodies, but this is the example I was more familiar with. So I think it won't be very, very different from what other institutions have put out. The essential logic is still the same, to demarcate the two parts of the contract and specify whether different laws should apply to the two parts. Okay, so that's choice of law. Maybe should I pause here, Dr. Detania, or would you like me to go to next step first?
Yes, maybe just briefly. Jadi kita lagi bahas klausula pilihan hukum ya. Jadi Prof. Yu lagi menjelaskan bagaimana prakteknya di Singapura, dan kemudian ternyata saya juga baru ini juga ya, this is something I first learned myself, Professor, about the possibility of constructing this kind of choice of law clauses. Bahwa mungkin ya dibikin klausula choice of law atau pilihan hukum yang berdasarkan kesepakatan para pihak ada keberlakuan dua yurisdiksi yang berbeda terhadap ketentuan yang berbeda terhadap klausula-klausula tertentu di dalam kontrak gitu ya. Jadi misalnya kalau kita lihat di layar ini ya, misalnya Prof. Yu menggunakan contoh ini, misalnya ini contoh klausulanya, misalnya dia bilang klausulanya mengatakan bahwa perjanjian ini kecuali untuk ya kan ayat B dan C di bawah gitu kan menggunakan hukum Indonesia misalnya, sedangkan untuk bagian B dan C menggunakan hukum Singapura. Nah, jadi ini memang jenis-jenis klausula pilihan hukum yang memang dimungkinkan ya dalam prakteknya di Indonesia, meskipun saya pribadi dalam melihat berbagai contoh kontrak ya di Indonesia belum pernah melihat contoh yang sedetail ini gitu ya, bahkan membedakan keberlakuan hukum untuk pasal-pasal tertentu, tapi itu kan tergantung kepada kebutuhan dan kesepakatan para pihak. Please move on, Professor.
Yes, thank you. And now let's see the choice of court clauses, which are also known as jurisdiction clauses. I don't want to talk about these in great detail, mainly for the reason that, based on my understanding, of course, Dr. Detania, please correct me if I'm mistaken, in Indonesia, the enforceability of these clauses is in some doubt. In Singapore, it's very straightforward. A court will give effect to a jurisdiction clause. Of course, there are some nuances to it, but in general, a court will give effect to a jurisdiction clause. But my understanding is that Indonesian courts don't always. And so it would be quite unwise, based on what I've read from Indonesian academics and practitioners, to place much reliance on a choice of court clause, because it might be given effect to, it might not be, and then so that sort of doesn't achieve the purpose that the parties have of wanting to have certainty. And because of this, it's not something that let me see how to put it. Yeah, it just in general, and not just specific to Indonesia. It's not a clause that I would recommend if you're dealing with a potential jurisdiction that may not give effect to the choice of court clause, because then you might just end up in the same kind of disputes, you would end up with even without the choice of court clause. Of course, arguably, it's better to have it there than not have anything. If you're the one who wants that court to be where the dispute is heard. But in general, people would usually, if you're dealing with cross-border transactions, where one party's state of origin may not give effect to the clause, parties would generally prefer to go for an arbitration clause instead, because those tend to be the position on arbitration clauses is a bit more harmonized across the world. And again, based on my limited knowledge of your jurisdiction, I think there's an act that deals with this and gives effect to arbitration clauses and all that. So there's more certainty there, right? But just for general knowledge, when you do have a choice of court clause, the way a common law court would look at it is that it would have a few effects. One is that procedurally, the agreement to the choice of court clause would be submission to the court's jurisdiction, and that would be a basis for the court to take jurisdiction of the matter, to take jurisdiction over the party. So basically, it's the basis for the court to have power over the party, both parties that have agreed to the clause. As a matter of contract law, it may also be possible that based on the language of the clause, the wording used, that clause might also create a contractual obligation to cooperate with proceedings commenced by the other party in the specified court. And this also means that where you have a choice of court clause, this becomes a basis to defeat proceedings brought in other courts. So for instance, if there's a choice of court clause specifying England, and a party tries to commence proceedings in Singapore, then the other party, if it's not happy with this, could do one of two things or both. The party could go to the Singapore court and say, hey, look at the contract we have. It specifies England. So you, the Singapore court, should either find you don't have jurisdiction, or you should stay proceedings, or something like that. So in other words, directed to the other court saying, please don't hear this dispute because we agreed on something else. A party could also go to the designated court, the chosen court. So in this example, if parties have chosen an English court, but one party tries to initiate proceedings in Singapore, the other party could go to the English court and say, hey, we have an agreement here which obliges the other party to only do to commence proceedings or cooperate proceedings here in the English courts. Please issue an anti-suit injunction directing that party to discontinue the proceedings in the Singapore courts, something like that. So these are two powerful weapons that a party can use when there's a choice of court clause and the other party tries to initiate proceedings elsewhere. Because of this, it is still useful for you to know about it, even if you might not choose to include such a clause in contracts that you draft, because if you're a disputes lawyer, for instance, you may have to deal with this argument that someone else raises, or you might want to go to another court and get an anti-suit injunction and stuff like that. So it's obviously more complicated than that, but it's something that is good to have at the back of your mind. Let me see. And before I move on from choice of court clauses to ADR clauses, I just want to note that this is a clause that usually goes hand in hand with the choice of law clause, because if you're going to specify that the dispute resolution clauses will be governed by and construed in accordance with the laws of, for instance, Singapore, that is usually going to be because you want to choose Singapore as the place for dispute resolution, either because you're going to choose, in this example, the Singapore courts in a choice of court clause, or you're going to choose arbitration seated in Singapore. So you want to make sure that the choice of law clause designates a law applying to the dispute resolution clauses that will match the jurisdiction where you intend to bring disputes. Yeah, so that's why I include choice of law in my presentation, because it is intertwined with choice of courts and also arbitration clauses. Okay, so maybe I'll pause here before moving on to the last section of my presentation, which is ADR clauses.
Okay, Professor, I'm going to elaborate a little bit in Bahasa, but then I'm going to share a little bit with you probably what happens in under Indonesian context. Jadi Prof. Liu sedang menjelaskan ya tentang masih tentang klausula pilihan hukum, kemudian pilihan ini ya pilihan forum ya. Pilihan forum ini berkaitan dengan penyelesaian sengketa gitu ya. Jadi beliau tuh baru menjelaskan contoh di mana satu klausula pilihan hukum yang umum itu juga sebenarnya bisa menjelaskan tentang penyelesaian sengketanya seperti apa, ya kan? Jadi kalau misalnya para pihak memilih hukum Singapura, berarti maksud para pihak itu ya berarti itu juga akan di apa namanya kalau terjadi sengketa juga akan diadili apakah di pengadilan ataupun di lembaga arbitrase di Singapura. Ya. Nah, tetapi menurut Prof. Liu dalam pengamatan beliau kalau dalam konteks Indonesia agak berbeda gitu ya. Bagaimana sih sebenarnya kekuatan klausula pilihan hukum dan pilihan forum ini? Nah, ini saya mau cerita sedikit sama Prof. Liu. So, Prof. Liu, you are right. Under Indonesian context, is a bit interesting that sometimes the court will decide that they have jurisdiction over case, even in the existence of, let's say, a foreign law choice or even a choice for alternative dispute resolution, because usually they will look into a few stuff first. First of all, whether what law governs the object of contract. If they think that the Indonesian law should apply because based on Indonesian law that all kind of contractual matters relating to a certain property or assets needs to be governed and settled under Indonesian law. So they will feel like, okay, it means that we have a jurisdiction under Indonesian law. But for arbitration clauses, it's also another problem, because even though that we have the law and arbitration, which generally stipulates that that the court has limited involvement, or they need to reject cases with arbitration clauses, but they have been a lot of cases in which that the court decided they still have jurisdictions, and there's still like an ongoing problem in Indonesia, unfortunately. Yeah, but when you mention about about how a general choice of law clause also relates to the choice of forum, this actually one very interesting Indonesian case between two companies, two Indonesian companies actually, is about an insurance case. They don't have a choice of forum. They don't have a choice of forum clause, but their choice of law is the applicability of English law. Both are Indonesian established companies, and then they went to court. The court was trying to decide whether they should apply English law and whether they should apply they should apply English law in Indonesian court, whether this falls under within jurisdiction and whether they need to apply English law, or whether the general choice of law clause means that this also falls within the under the English court jurisdiction. And the case went up to the Supreme Court, and the Supreme Court decided that this case should go to English court, right? But unfortunately, well, I think you're also familiar about our legal system that court decisions are not binding in Indonesia. So it means that for similar cases in the future, there have been a variety of different different decisions with regard to this issue. So we decided that it would always be best to have both choice of law clauses and also the choice of forum clauses, because otherwise it can be interpreted differently. Even with the existence of an arbitration clause, for example, like I've mentioned to you, there have been a lot of examples when the court decided that we still want to look into the case anyway, that we have jurisdictions, and that of course creates legal uncertainty and portrays the dynamics of Indonesian legal proceedings. Just sharing a bit with you on that. Let's move on. Sorry for too much information.
No, thank you. That's fascinating, because I think that is new information to me on the arbitration side. Very interesting. Thanks. And just to pick up on something you mentioned about how in that particular case your Supreme Court held that the choice of law of English law was, and it also meant that an English court should be hearing the case, but that doesn't set a binding precedent. Interestingly, even in common law, I don't think there is any such binding precedent, because the common law position is that in the absence of an express choice of law clause, it's a sort of factor-based analysis. And so choice of law, choice of governing law is a very strong factor. It may be a strong factor pointing towards a particular jurisdiction's courts, but there are other factors as well. And because of that, it's not possible under the common law either to say that if there is no choice of court clause or a choice of forum clause, but there is a choice of law clause, then that jurisdiction's courts will be the appropriate forum. It's not possible to say that with certainty. So even in the common law system, there is lasting uncertainty on what will happen in such cases. And that makes it all the more important, as you said, Dr. Detania, to specify a choice of forum as well as the choice of law. Otherwise, you're introducing more and more uncertainty into the contract. Okay, with that, I'm going to move to the last section on ADR clauses, alternative dispute resolution clauses. And alternative there, of course, refers to alternatives to litigation. And the main forms of ADR are negotiation, mediation, and arbitration. Negotiation and mediation are both voluntary settlement mechanisms because, well, in negotiation, the parties discuss directly and they may agree or they may not agree. In mediation, parties discuss, but they have the assistance of a mediator who is neutral and does not make a decision. The mediator just facilitates the discussion. Again, settlement of the dispute is voluntary. Arbitration is different. Arbitration, as you probably know, is more like litigation. The decision made by the arbitral panel is binding. So starting with negotiation, interestingly, in English law, traditionally, negotiation clauses were not enforceable. The English courts took the view that a negotiation clause is basically purportedly an obligation to negotiate with each other in good faith, but English courts thought that was too uncertain. And maybe this is partly a reflection of the very limited role that good faith has under the common law. As I mentioned, it is possible to import good faith into the performance and interpretation of a contract by agreeing to it, but it doesn't have general applicability. And so courts were of the view that, well, when you're talking about the negotiation stage, when you're negotiating the resolution of a dispute, what does it even mean to negotiate in good faith? how can there be good faith or bad faith when you are deciding whether you are satisfied with what the other side is offering, for instance? And what is negotiation? If I just read your email and I say no thanks, have I negotiated or have I not? So because of concerns like that, English courts traditionally thought that an obligation to negotiate was unenforceable. The tide may have changed in the UK. There's a High Court decision, and I put the name up there in 2014, but I'm not sure if it's fully resolved as of now. In Singapore, however, and in some other jurisdictions, like I think Australia, for instance, it is quite well established. A negotiation clause is enforceable, but a lot depends, even in jurisdictions that are more friendly towards negotiation. It's wise to specify what exactly you mean by negotiation, like who is supposed to negotiate, what's the mode of negotiation, because the more specificity you are able to give, the more likely it is that a court would find that it's certain enough to enforce. With the Singapore court, probably not a big problem, but English courts, for instance, can be very picky. For an example of a famous or infamous case where the English court held that a clause was insufficiently certain, there's the Sul America case in 2012, quite an important one for various reasons, but this is one of the interesting aspects of the case. Okay, so that's mediation. Let's see. Sorry, so that is negotiation. Sorry, I got them mixed up. The Sul America case is actually a case where that was extended to mediation. So actually, that goes to show how particular English courts can be. But actually, I shouldn't get them mixed up. Earlier, I was talking about negotiation, and the position there. Sorry for the confusion. To recap, it is an enforceable obligation in Singapore and some other common law jurisdictions, but in England, uncertain whether it would be enforceable. So maybe I'll cover mediation and then I'll take a pause before covering arbitration. Mediation is pretty similar, except that you have a designated person to facilitate the process, unlike negotiation. And this is enforceable in pretty much all common law jurisdictions. And even in England, mediation agreements can be enforceable, but this is where the Sul America case I mentioned earlier comes in. Sorry for the confusion. The English courts tend to be more picky about how much detail they want before they are willing to find that the clause is enforceable. So what they want is essentially clear indication that the parties agreed to be bound to mediate. So not just have an intention or be open to mediation, but there has to be language suggesting that it's mandatory. And second, they want details like who is the mediator or what's the procedure for appointing mediators. The normal way to deal with this would be to designate a mediation institution and to adopt their rules. Because once you say mediation in the Singapore Mediation Center, for instance, using the Singapore Mediation Center rules, then inside those rules, there would be the procedures for appointing mediators, and there would be details on the mode of mediation, all that. And so even an English court looking at that would probably enforce it because there's great certainty as to what exactly the parties would be obliged to do. Okay, so maybe I'll take a pause here. And for context, what I'm going to cover after is I'm going to cover arbitration clauses, and then very briefly, I'm going to talk about multi-tiered dispute resolution clauses, where more than one form of ADR is provided.
Oke, thank you, Professor. Jadi Prof. Liu baru menjelaskan ya tentang bagaimana kekuatan hasil negosiasi dan mediasi, ya kan, sebagai salah satu bentuk alternatif penyelesaian sengketa. Terus kemudian beliau juga ada menjelaskan ya bagaimana ada kasus-kasus yang melibatkan hasil negosiasi. Tadi Prof. Liu bilang bahwa berdasarkan hukum Inggris itu sempat ada putusannya pengadilan bahwa putusan negosiasi itu nggak memiliki kekuatan hukum, tapi menurut beliau sekarang sudah terjadi perubahan gitu ya. Kemudian juga kalau proses mediasi ya itu juga ada ketentuan-ketentuan ya bagaimana prosedurnya, kemudian bagaimana penunjukan para mediatornya. Prof. Liu, I have one question about mediation. So, does the mediation result does it need to be put into a written some sort of like a written act to be able to to get in to be enforceable, Prof. Liu?
Yes, I think this would depend on the jurisdiction. I am, to be honest, I'm not entirely certain what Singapore's position on it is, and I think the reason, one reason that this doesn't come up very much is that as a matter of practice, mediators will always make sure that if the parties have come to an agreement, they put it in writing. So it's something that I can imagine in some ad hoc mediations run by not very experienced mediators. This could be an issue, but usually if you're going with an institution, as most mediations, at least in Singapore, do, it would never be an issue because as a matter of course, everyone knows you will record it in a signed agreement. So I think, yeah, my answer is just that it differs by jurisdiction, but universally the prudent best practice is to always have a written agreement recording the understanding reached at the mediation. There's also there's a mediation convention that was signed in Singapore that I think may have some standardizing rules on this, but I'm not sort of a very expert in mediation, so I won't make any claim as to what they say. But for those who are interested in seeing the sort of international attempts to standardize approaches to mediation, it's worth giving the mediation convention a read. If I'm not mistaken, I don't think Indonesia is a party to it yet. I don't think so, but it's quite a recent convention, I think just a few years back. So, well, it'll be interesting to see if in time it gets more traction internationally.
Thank you, bro.
Okay, so I'm going to move on to the last part, arbitration, and then I'm going to talk about, the last two parts, arbitration and multi-tiered dispute resolution clauses. So most common law jurisdictions take a pro-arbitration stance these days. Singapore is probably one of the most pro-arbitration jurisdictions out of the whole lot. Our courts have many a time expressly stated that we take a pro-arbitration position. And one example of how strongly pro-arbitration Singapore courts can be is in this case of KVC Rice Intertrade. In the interest of disclosure, I did assist on this case as a law clerk some years ago. And this case involved a really ambiguous arbitration clause. It said the seller and the buyer agree that blah, blah, blah shall be referred to and finally resolved by arbitration as per Indian contract rules. And it was very unclear what Indian contract rules meant because there's no real body of rules or there's no act or anything by the name Indian contract rules. And this particular contract didn't seem to have anything to do with India either. And so it seemed to have been copied over from a different contract that did have to do with India. So very puzzling arbitration clause. And as you can see, it did not state any arbitral institution. It did not specify venue or seat for the arbitration, which I'll talk about briefly in a moment. But the Singapore court, I don't have time to go into the details. It's an interesting case if you want to read it. But the Singapore court basically did its very best to interpret this clause in a way that allowed it to give effect to the parties' intention to arbitrate, even if the parties were not very clear on where and how they wanted to arbitrate. So just in general, Singapore court is very pro-arbitration, because the idea being that, well, when parties include such a clause, their intention is that they would prefer to arbitrate. And parties' intention should be respected, both because that is a tenet of contract law, and also because from the point of view of conserving public resources that would otherwise be occupied if the case were to go to the courts, it's desirable to give effect to those wishes and to therefore lighten the load on courts. So those are at least two reasons why Singapore is pro-arbitration. But okay, even though Singapore courts and other common law courts tend to be pro-arbitration, it is very unwise to draft a clause that looks like this. It is much better to not leave it in the hands of the court and see if the court is going to rescue your clause or not. Instead, as you'll learn if you do an arbitration class, you want to make sure certain significant details are always there. What's the arbitral institution? What rules do you want to use? How should the party commence arbitration? How are you going to select the arbitrators? How many arbitrators are there? And extremely important, what's the seat of arbitration? The seat of arbitration is basically the legal place of the arbitration. It need not be the same as the physical venue of the arbitration. You can have an arbitration that is seated in England, in London, for instance, but the actual hearings take place somewhere else in the world. That's entirely possible. But the seat is very important. Mainly, well, the seat is important for two reasons. One is that by default, it will be the law of the seat that applies to the arbitration procedure. And two is that it is the court of the seat that will have supervisory powers over the arbitration. So the seat is extremely, extremely important. You could also include details like physical location. That's more a matter of practicality. It doesn't affect the enforceability of the clause, but you may want to specify it because just for logistical reasons. The language the arbitration will be conducted in. And finally, whether the parties are willing to let the dispute be decided ex equo e bono, or another term used is whether the tribunal can decide it as amiable compositor, meaning can the tribunal decide this based on fairness and equity rather than on strict legal rights. So this is something that I've noticed common law parties very rarely do. It's the very unusual common law party who will agree to such a clause. And I'm guessing it's because common lawyers advising them would usually say, well, that introduces a lot of uncertainty. Don't do it because I as a lawyer can't advise you on what a tribunal will think is equitable or fair. And so common lawyers will usually tell their, whether in-house or external counsel will usually advise clients, no, don't put this in. But stepping outside the lawyer's role for a moment, just looking at it from the point of view of parties, it can make a lot of sense to include this because the actual commercial parties, unlike us lawyers or law students, aren't especially interested in the law. They want their transaction to work, and they want a way to work out problems when they arise. So actually, maybe it is worth being a little bit braver sometimes and being more open to such clauses. And I'd be interested to hear if civil lawyers like yourselves have a different view of this, because I can tell you common lawyers looking at a proposed clause to allow a dispute to be decided ex equio e bono will immediately say no, no way. But that may not actually be best for the clients sometimes. Okay, that is, maybe I'll take a quick pause here. Actually, no, I'm almost out of time. So let me instead quickly cover the tiered arbitration clause thing. Basically, I'm just putting together what's come before. We've talked about negotiation, mediation, arbitration. Just know that it's very common now for clauses to have some combination of these options, or maybe all the options. And often it is tiered. Tiered meaning first you have to negotiate. Only if you negotiate and it doesn't work, then you have to go to mediation. And only if mediation does not result in a settlement, then one party or the other can commence arbitration or commence court proceedings. So this is a very useful way to try to resolve disputes efficiently, at least if parties are operating in good faith. If they're not operating in good faith, it can become a way to drag out a dispute. So that's the downside to it. And these clauses can be enforced by courts, at least by common law courts, in various ways, depending on the situation. For instance, in some cases, you might see a party challenging a tribunal's decision that it has jurisdiction. They might go to the supervisory court and say, hey, this decision by the tribunal that it has jurisdiction is wrong because the other party has not complied with the earlier part of the tiered arbitration clause. They didn't negotiate with us before commencing arbitration. And therefore, because the precondition to arbitration is not satisfied, the tribunal lacked jurisdiction, right? So that's one example. And there was a Singapore court case, quite well known in my jurisdiction, where the court agreed with the party bringing the application in court and held that the party commencing arbitration was premature. They failed to negotiate first, and so they had to do that. Other things that you can do are to seek a stay of proceedings, or even an order of specific performance, where you go to the court and you say, this person is not mediating with me. I want an order that they come and mediate. You can even get that in some jurisdictions. Okay, and this is my very last point. This is quite interesting. It is even possible to have a multi-mechanism ADR clause that is not tiered. So in this recent Singapore court case, there was this interesting set of clauses. There was a negotiation requirement, and then if negotiation failed, the parties were obliged to, the word is shall, the parties shall refer the dispute for mediation. At the same time, there was also an arbitration clause, and interestingly, the mediation clause said that mediation is not a condition precedent for reference to arbitration. So this went to the court because basically one party, even though arbitration had already started, one party said, hey, even though we're arbitrating, we should also mediate. And the other party said, what's the use? We're already in arbitration. Mediation would be a waste of time. But the Singapore court said, no, the mediation clause is phrased in mandatory fashion, and there's no contradiction in the parties pursuing arbitration and mediation at the same time. Arbitration will result in a binding award, but maybe mediation in the meantime might allow the parties to conclude an agreement, and then they can discontinue the arbitration proceedings. So this is an interesting example of how different ADR mechanisms can actually coexist at the same time. And it makes sense because logically, there's nothing to prevent parties from going through the arbitration or litigation process while also trying to settle their disagreement by mediating or negotiating. Yeah, okay. So this brings me to the end of my planned material, and I also the end of our allotted time. I'm sorry there isn't more time available for questions. Of course, I'm in Dr. Detania's hands if we want to take more questions. But if you have questions that we don't have time for in this session, My email address is at the bottom. I'm happy to entertain queries on anything that I've discussed or didn't have time to discuss. And thank you all once again.
Thank you very much, Prof. Liu. Jadi semuanya tadi Prof. Liu menjelaskan ya kalau di Singapura itu arbitrase itu sangat apa ya, bukan dilindungi ya, tetapi ketika sudah ada pilihan berarbitrase itu pengadilannya pasti akan menghormati begitu ya. Bahkan di dalam contoh kasus di mana klausula arbitrase itu di dalam kontrak itu kurang kuat gitu ya, atau ambigu gitu ya, tapi ternyata itu pun masih ditegakkan gitu ya. Dan kemudian tadi juga Prof. Liu menjelaskan beberapa contoh klausula penyelesaian sengketa yang sifatnya itu dia bertingkat higher gitu ya. Jadi misalnya dimulai dulu dengan pilihan negosiasi atau musyawarah, mungkin kalau dalam kasus ini biasanya musyawarah dulu. Kalau tidak berhasil baru dicoba mediasi. Kalau tidak mediasi berhasil baru para pihak bisa berarbitrase ataupun ke pengadilan. Jadi itu adalah contoh higher structure dalam sebuah klausul penyelesaian sengketa. Lastly, I think one question. Have you ever seen a dispute resolution clause that puts both arbitration and court proceedings in the same clause?
Yes, interesting. I mean, I have seen such contracts, some such clauses before. Sometimes a clause will give a party the option, and it could give either party the option. Then it becomes a question of who acts first, right? Or it could give one party the option to elect, and common law courts will give effect to that. So, for instance, you might say, if negotiations fail, parties shall resolve the dispute by arbitration in this jurisdiction, blah, 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 or litigation in the courts of whatever country at the option of the plaintiff, something like that. Sorry, at the option of party A, or something like that. And that is fine. Of course, once you do that, it does create some uncertainties. And I've seen arguments, for instance, that that this sort of lopsided bargain is unfair if only one party has the option, or if both parties are allowed to choose, and then it's a question of who initiates what first, then that can sometimes create undesirable situations where you're sort of rushing to pull the trigger first and initiate proceedings or arbitration first. So there can be downsides to it, but in principle, it's possible to have such a clause, and it is done sometimes.
Okay. Professor, there are no questions from the students so far, but I think we have run out of time. And as you've mentioned, that if there are any questions later on, if you're okay, they can probably email you to your provided email ya. Jadi kalau ada pertanyaan nanti buat Prof. Nicholas ya, atau mungkin mau tanya-tanya tentang mungkin suatu hari mau kuliah S2 mungkin nanti di Singapura, atau pengen mungkin berkarir hukum di Singapura, boleh ya menghubungi Prof. Liu melalui email yang beliau sudah cantumkan ya di PPT. Kan nanti pertanyaan lebih lanjut nanti bisa saja nanti ini juga didiskusikan dalam kelas minggu depan ya bersama Ibu Cantik saya di sana. Sebelumnya saya juga mau mengucapkan terima kasih buat semuanya atas kehadirannya. Prof. Liu, on behalf of the Faculty of Law, I would like to thank you so much, for saying yes, for making time for us to deliver such a fruitful lecture, Prof. Liu, and I really hope that there will be similar opportunities in the future for us to interact and discuss further on contract law, tort law, or other topics in the future, Prof. Liu. Thank you very much, Prof. Liu.
Thank you very much too. It's been a great pleasure delivering these talks. And thank you for the wonderful and insightful questions and also the translation. Thank you.
Yeah, my pleasure. Thank you. Have a good day. Terima kasih ya semua. Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi. Terima kasih Bu Ita. Terima kasih semua. Thank you, Prof.